Welcome to the next episode of Small Business Legal Tips. So, you've found the ideal business to buy. The financials look good, the brand is strong, and you can already envision yourself in charge. You're ready to sign the paperwork and begin this new chapter. But wait a minute. Before moving forward, understand that a single overlooked detail about the business or any contract can turn a promising opportunity into a financial catastrophe. One misstep is all it takes to jeopardize your investment and cause you years of heartache. I'm attorney Mark Bross of Bross Law LLC. I'm a practicing business attorney in Massachusetts, and I've helped countless entrepreneurs successfully buy businesses. In this video, I'll go over the essential legal steps that you want to take in order to successfully buy a business with minimal risk. There are no guarantees, of course, but this framework will help you protect your investment and ensure the acquisition process proceeds smoothly. Don't consider buying a business until you've reviewed and followed these critical steps. And please, if you'd like to get more helpful legal tips, please hit the like and subscribe button below. It really lets me know that you'd like to receive more videos like this. So let's get to it. Embarking on a business acquisition is a high-stakes endeavor. After many months of planning and saving, you may find an opportunity that feels perfect. While that excitement is a powerful motivator, it can create blind spots that expose you to significant risks that lie just below the surface. Excitement and the fear of missing out can lead buyers to rush the process. But a successful acquisition requires diligence and a methodical approach. You need a clear, strategic legal game plan like the framework I'll present in this video. Think of it as a comprehensive checklist designed to help you navigate the complexity of buying a business and safeguarding your future. Step 1. Assemble your professional team. The first critical step is acknowledging that you cannot navigate this process alone. Buying a business is not really a do-it-yourself project. It's a team sport. The seller likely has professional representation in their corner, and you need someone to help you protect your interest. This is non-negotiable for a safe and smooth business transaction. Your team requires at least 2 key players, a business attorney and an accountant. A common mistake is attempting to cut costs by relying on the seller's documentation and the seller's representatives. This is equivalent to entering a high-stakes game of poker without understanding the rules. You need a business attorney with experience in business acquisitions in order to represent your interest in the transaction. They are trained to identify red flags in contracts and will make sure that all transaction documents also protect your interest. Your accountant serves as your financial detective. They will conduct a thorough examination of the company's financial records to ensure that the numbers align with the seller's claims. By analyzing past tax returns and current financial statements, they'll provide a true assessment of the business's financial health. The best predictor of the future performance of a business is its past performance. So you'll want to make sure that you fully understand the financial information that the seller is presenting you to make sure the business is actually worth your time and money. Underestimating the need for this expertise is a big mistake. The cost of hiring professionals is minimal compared to the overall value of the deal and the potential losses that can occur from a single oversight. Your lawyer and accountant are not just service providers, but are also strategic advisors who can help you evaluate the business and protect you from hidden liabilities. Don't skip this step. Your professional team is the first and best investment you'll make in the acquisition process. Step 2, the letter of intent, also known as the LOI. After your professional team is in place, you're ready to make a formal offer on the business. This is accomplished through a letter of intent or an LOI. The LOI is a preliminary document that outlines the proposed framework of the deal. It functions as a blueprint for the final purchase agreement, specifying the purchase price, the deal structure, a timeline, and other key conditions. The LOI is not just a mere formality, and you shouldn't just rely on whatever form the business broker or the buyer has produced without having your attorney review it. Many of the clauses in an LOI, such as the purchase price, the proposed closing date, and various other clauses are not binding. They can be changed as a result of due diligence or other factors, and these won't change or blow up the deal. However, any LOI should also have various clauses that are binding and can't be changed without blowing up the deal or breaching the LOI. Here are some of the key clauses that are typically binding in an LOI. First, if you plan on obtaining financing to buy the business, you need to make sure that this is clearly stated in the LOI and that it's a condition of the sale that you obtain financing to buy the business. That way, it won't be a problem if you don't obtain financing and you won't be forced to forfeit your deposit if you don't obtain financing for the business. Second, another key clause that should be binding in the LOI is that the parties will sign a more definitive purchase agreement as part of the transaction. I'll talk about this more in a minute, but you need to make it clear that this LOI doesn't commit you to buy the business because there will be a more definitive agreement in the future. Third, your LOI should also specify how long you plan to conduct due diligence for, the specific categories of information you want to obtain, and that you will have the right to back out of the deal if you don't like what was discovered in due diligence. This clause should also be binding on the parties so that you can back out of the deal anytime if you don't like what was discovered in due diligence. Fourth, another clause in the LOI that should also be binding is an exclusivity provision, which is also called a no-shop clause. The no-shop clause legally prevents the seller from negotiating with other potential buyers while the LOI is in effect. A strong no-shop clause secures your position in the offer you've made on the business. If another buyer emerges with a competing offer after your LOI has been signed, the seller is contractually obligated to honor their exclusivity agreement with you. Without this protection, you risk being drawn into a bidding war with the other buyer or losing the opportunity altogether. There are lots of other clauses that could also be enforceable in the LOI, depending on what you want to guarantee as part of the final transaction. Although preliminary, the LOI is critical and sets the foundation and tone for the entire transaction. Don't ignore it. Step 3, the due diligence investigation. After the LOI is signed by both parties, the next step is for you to conduct due diligence and investigate the business. This step is critical. Due diligence is your formal investigation into the business and allows you to obtain all the information that you need to evaluate the business and make sure that it's a business really worth buying. Rushing or overlooking this step is the single greatest mistake a buyer can make, and it is the primary cause of post-acquisition surprises and liabilities. This is where your professional team provides its greatest value. Due diligence involves a comprehensive top-to-bottom review of all aspects of the business that you're considering buying. I've already talked about how to conduct due diligence in detail in an earlier video, and I won't go through all of that again here. I'll put a link to the earlier video below in the description. But as a brief summary, in due diligence, you and your team are going to look in detail at the finances of the business, the corporate structure of the business contracts, its intellectual property, its employees, its customers and suppliers, and anything else that can impact the operations and profitability of the business going forward. No stone should be left unturned. And this is the process that will uncover any potential deal-breaking issues or show you that you need to renegotiate the purchase price with the seller. Step 4, the purchase agreement. While you're conducting due diligence, or afterwards depending on the deal, the next step is to draft the final legally binding contract governing the transaction. The purchase agreement, which is also called the PA. This is not a generic document that's downloaded from the internet or created from some form template. It must be carefully drafted by your attorney to address the specifics of your deal and will be heavily negotiated with the seller's attorney. The PA is the comprehensive definitive agreement that governs the transaction and will replace the LOI. Unlike the LOI, every clause will be binding on the parties. Here are some of the key clauses that will go in the PA. First, every PA should describe exactly who the parties are to the agreement. Obviously, you're going to have a buyer and a seller, but you need to identify exactly who they are. For the seller, you want to be clear whether the seller is an entity like a corporation or an LLC, a limited liability company, or the owners of these entities. Often it's both, but you want to be clear about this upfront because it will impact various other clauses in the agreement. With respect to the buyer, you want to be clear about whether the party buying the business is an individual or a collection of individuals, or whether it is a corporation or an LLC buying the business. Usually it's a corporation or an LLC buying the business because even if an individual or collection of individuals sign the LOI, they likely want to set up a new entity in connection with buying the business. So that will need to be specifically identified in the PA. Second, every PA needs to identify exactly what is being bought and what isn't being bought. If it's an asset purchase agreement, the PA needs to identify thoroughly and accurately what assets are being purchased and what assets are being excluded. This is often done in various exhibits attached to the purchase agreement, where all the assets being purchased are identified in one exhibit and all the assets that are not being purchased or excluded are identified in another exhibit. Keep in mind that if you are buying a business by buying its assets, which is the most common form of business acquisition, the list of assets being purchased is critical because you are not buying any asset that is not on the list. If it's a stock purchase agreement, it's not as essential to identify all the assets being purchased, because by owning all of the shares of the business, you automatically own all the assets and all the liabilities associated with the business. However, in a share purchase agreement, it's critical to identify exactly what shares of the business you're buying to be sure that you're actually buying all of the issued and outstanding shares associated with the business. If you don't buy all of the issued and outstanding shares associated with the business, you're only buying part of the business. Third, every PA should also state exactly what the purchase price is, when it is being paid, and how it will be paid. There are lots of different possibilities here, and a lot of it will depend on how complex your deal is. But it's not uncommon to have part of the purchase price paid by certified check or wire at the closing, and part of it paid by a promissory note from the buyer to the seller. It's also not uncommon for the buyer to pay part of the purchase price as a deposit in connection with signing the PA, or for part of the purchase price to be held in an escrow account for a period of time after the closing to make sure that the business is as promised by the seller and lives up to the buyer's expectations. Work with your attorney and your accountant to determine what makes sense. Fourth, every PA should also set a date for when the purchase of the business will actually occur, which is known as the closing or the closing date. This is the date when the ownership of the business will actually transfer to you and the transaction is finalized. In connection with the closing date, the PA should also identify several related items, such as what documents are going to be signed at the closing and what conditions need to be met in order for the closing to occur, which are called the closing conditions. Some common documents that are signed at the closing are a bill of sale, promissory notes for any amount that's being financed by the seller, security agreements, intellectual property assignment agreements, non-compete and non-solicitation agreements for the former owners, and various other agreements. All of the documents signed at the closing ensure that the seller actually gets paid the purchase price for the business, and also ensure that the buyer actually owns the assets of the business after the closing, and that the former owner won't interfere with the new buyer's operation of the business. With respect to closing conditions, some of the most common ones are that the buyer has obtained a new lease or an assignment of the lease from the landlord, and that the buyer has obtained whatever licenses are needed to operate the business. For example, if you're buying a restaurant, you want to make sure that you've obtained a victualler's license and whatever other permits are needed to operate the business prior to the closing date, so that you can begin operating the business on the closing date. And if you're obtaining outside financing, another common closing condition is that the bank has approved the loan by the closing date. If any closing condition isn't met, the closing can't occur and the whole deal is off, no matter what any other provision in the PA states. A fifth clause that every PA should have is a representations and warranties clause, which is also just called reps and warranties. Reps and warranties are assurances given by both parties to the agreement that disclose material information and allocate risk among the two parties. Although both parties provide reps and warranties in the PA, the seller's reps and warranties tend to be much more extensive because they include information about the target company or the assets being sold. Some common reps and warranties by the seller are that all financial information provided by the seller is accurate, all assets are in good repair, all taxes have been paid or will be paid at the closing, there is no undisclosed litigation or liability, and many, many others. Reps and warranties are often one of the most heavily negotiated aspects of a purchase agreement. Your attorney will work to make sure that the PA includes language in the reps and warranties section that best protects your interest in connection with the business you're acquiring. There are lots of other clauses that will go into a PA. The length and the complexity of the PA will greatly depend on the business that's being bought and the terms of the transaction and the deal. Work with your attorney to make sure that the PA best protects your interests, accurately reflects the transaction, and gives you legal recourse in case the transaction fails or the business is not as advertised. Step 5, the closing. The next step in acquiring the business is the closing. The closing usually occurs at one of three locations: one of the attorney's offices, the bank if there's financing involved, or possibly the location of the business if the business only has a single location. The exact location will be set out in the PA. At the closing, all the parties and their attorneys will attend, and all the documents that were identified in the PA will be signed. Additionally, each of the parties usually sign bring-down certificates, which basically state that all of the reps and warranties contained in the PA are still true and accurate on the closing date. The buyer, of course, will also need to pay the purchase price to the seller for the business in whatever form was identified in the PA. There will also likely be some closing adjustments to the purchase price depending on the current condition of the business and changes that have occurred since the PA was signed. The most common closing adjustment to the purchase price are changes based on things like the business's working capital, inventory levels, accounts receivables, outstanding debts, and various other things. For example, if you expected to buy a business with $100,000 in working capital, but it only has $80,000 on the closing date, this change would cause a downward change in the purchase price. The factors that can cause an adjustment to the purchase price at the closing should be identified in the PA, and these closing adjustments ensure that the final payment is fair to both parties and as agreed upon. At the end of the closing, you are now the proud and official owner of a new business. Congratulations! However, there's still one more step that needs to be taken. Step 6. Post-closing matters. After the closing, there are a few more post-closing matters that need to be taken care of. First, if you are acquiring the assets of the business, then you will need to hire all of the old employees of the business to the extent that you want to keep them. From your due diligence, you should know who the employees are and what pay and benefits they receive. These employees were laid off by the buyer right before the closing. So to the extent you want to keep them, you need to hire them. In order to prevent a mass exodus of workers, I highly recommend that you offer them pay and benefits that are identical or better than what they previously received. If you bought all of the shares of the business through merger or acquisition, there is no need to take the steps as the employees were not laid off. However, I would recommend having meetings with the employees either before or shortly after the acquisition in order to answer any questions or soothe any fears that they may have. Second, you also need to reach out to all customers, vendors, and suppliers to make sure that these accounts are transferred to you without any break in service and to ensure continuity in business dealings. This should be undertaken with the seller, so you need to make sure that your PA provides for some post-closing assistance by the seller to transfer these accounts. The amount of post-closing assistance required will depend on the type of deal and how much help you need. Third, you also need to make sure to file all necessary filings with various state and federal agencies. The most common filings are UCC financing or termination statements, intellectual property assignments with the United States Patent and Trademark Office or the U.S. Copyright Office, a DBA business certificate, and business license transfers or changes of ownership. Each of these filings must be made to make sure that the assets of the business are properly transferred to you after the closing. Fourth, most purchase agreements will require each party to engage in some actions after the closing, which are called post-closing covenants, in order to ensure a smooth transition. For example, both parties will agree to cooperate about how they're going to report the purchase price allocation to the IRS and other taxing authorities. And the seller often promises to provide transition assistance to the buyer in some fashion, and also not to compete with the buyer or solicit any customers or employees from the business after the closing. Buyer and seller should do their best to make sure that these promises are complied with in order to prevent future lawsuits over the transaction or any disputes over the release of escrow funds. In conclusion, acquiring a business is one of the most rewarding and stressful activities you can undertake. There are many possible pitfalls in the process, and your success hinges on a disciplined and strategic approach like the one outlined here. To summarize, here are the 6 steps you need to take. First, assemble an expert team that consists of a business lawyer and an accountant. Second, establish the deal's framework with a letter of intent and make sure that certain clauses are binding, such as the exclusivity clause. Third, conduct thorough due diligence and investigate every aspect of the business. Fourth, negotiate and draft a complete purchase agreement that accurately describes the deal and protects your interests after you own the business. Fifth, sign all documents at the closing and pay the purchase price. And sixth, follow through on all post-closing matters that need to be performed, like hiring the employees, contacting vendors and customers, filing all required forms with the appropriate government agencies, and various other actions. I hope you found this information helpful. Before you go, please hit the like and subscribe button and ring the bell to get notifications of when our next episode drops. Thank you so much for watching, and I'll see you next time.